This presentation will be addressing specific questions regarding the legal status of war during the League of Nations period, and the effectiveness of international law at this time in limiting states from going to war, as well as the exceptions to the prohibition on the use of force with international law under the United Nations. In addition, applicability of this prohibition to non-state actors or terrorist organizations. The first question will be considered: what was the legal status of war during the League of Nations period? And how effective was international law at this time in limiting states from going to war? First of all, in order to understand and address the questions, I will briefly review the historical background. Early in history, war was the purpose of promoting strategic interests or territorial acquisition. However, after the Age of Enlightenment and the French Revolution, this way of thinking begins to change. It is particularly important because it formed the basis of customary international law on the use of force in the Age of Enlightenment. After the French Revolution, a constitution was drafted that limited the king's powers aimed at conquest and renounced all wars. Therefore, these changes influenced the formation of our current international and customary international law. In the early 20th century, various attempts were made to regulate the use of force before the First World War. The first question is about the legal status of war during the League of Nations period. The League of Nations, established after World War I, made a joint attempt to limit the use of force in international relations. The Covenant of the League of Nations 1919 imposed procedural restrictions on states to reduce their likelihood of warfare. It intended to reduce the state's dependence on force as a method of conflict resolution. As stated in Article 10, states have an obligation to respect other states' territorial integrity and political independence. There are two significant developments. On 25 September 1925, the Sixth General Assembly of the League of Nations passed a resolution stating that wars of aggression constitute an international crime, and the provision of the League of Nations Covenant marked an essential development in an effort to prohibit the use of force by states. The General Treaty on the Renunciation of War 1928 Kellogg-Briand Pact is a treaty in force today. The Kellogg-Briand Pact was recognized as the background of customary international law on the prohibition of the use of force. Two key provisions are: first, states must not rely on war to settle international disputes. Second, states have an obligation to settle disputes only through peaceful means. The next question is: how effective was international law at this time in limiting states from going to war? At that time, there are two significant effects of international law limiting states on going to war. First of all, reducing the state's reliance on war as a method of resolving disputes. Second, it had a significant effect on the development and change of the current customary international law. However, the ineffectiveness of international law at that time was that it did not prevent conflicts, such as the events that caused the outbreak of the Second World War, and it fell short in prohibiting the state from going to war. Next, seminar question number 3. There are two specific questions. First, what are the exceptions to the prohibition on the use of force? Second, does this prohibition apply to non-state actors such as terrorist organizations? I'm going to talk about exceptions to the prohibition on the use of force. The UN chapter provides for exceptions to the prohibition on the use of force. First of all, the use of force authorized by the UN Security Council. According to Article 42 of the UN Charter, should the Security Council consider that it may take such action by air, sea, or land forces as may be necessary to maintain or restore international peace and security. Such action may include demonstrations, blockade, and other operations by air, sea, or land forces or members of the United Nations. In addition, Article 51 is about the use of force in self-defense. The present chapter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken measures necessary to maintain international peace and security. UN Chapter and UN Security Council play a significant role in managing the use of force in international law. Last but not least, the question is, does this prohibition apply to non-state actors such as terrorist organizations? Mary Ellen O'Connor states that international law reflects that both the non-state actors and terrorist groups are largely regulated by national law. The act of warfare is directly regulated under international law, and terrorism and terrorists are still subject to national law. For example, after happened 9/11 in 2001, the United States argued that they has the right to eliminate the threat posed by a rogue state and terrorists. It targeted not only about state but also non-state actors. Thank you for listening to my presentation.